from St. Louis Public Radio. This is St. Louis on the Air.
I'm Sarah Fensky.
My name is Kevin Johnson. I've been sentenced to death. I've grown. I'm a better person. I'm caring. I think I could be more of a help for people alive than dead.
Kevin Johnson killed a Kirkwood cop as a teenager. Now he's making what likely is his final plea to avoid execution. The special prosecutor on his case now wants the Missouri Supreme Court to put a halt to his death sentence. That effort will come to a head in the next week. And in recent weeks, we've also seen a six-figure verdict against a local Mercedes-Benz dealership. And we've seen the city of St. Louis beat back a lawsuit that challenged its ban on giving sandwiches to homeless people without a permit. Our Legal Roundtable is here today to help us make sense of all of these matters. And today, that panel includes Erin Banks. He is a former state prosecutor and city councilor for the city of St. Louis, and he is now an attorney and mediator at Banks Law. Erin, welcome.
Thank you.
And today we're also joined by Mark Smith. He's a former associate vice chancellor and dean at Washington University. He taught law courses there for 30 years, and he's currently teaching a law class at the Missouri Eastern Correctional Center in Pacific, Missouri. Mark, welcome back.
Great to be here.
And last but not least, making her Legal Roundtable debut is Erin Lueker. She was previously a public defender for St. Louis County and a prosecuting attorney for the state of Missouri. She's now at the firm Sade Harper Westoff, and she focuses on employment law. Erin, welcome.
Great to be here.
So we have a lot to talk about today, and I think that needs to start with a life or death case. Kevin Johnson, we heard his voice earlier. He's scheduled to be executed by lethal injection next Tuesday, November 29th. Now, the Missouri Supreme Court just set oral arguments in this case. It could halt Kevin Johnson's execution on Monday. That is just one day before he's set to be killed. Now, that hearing comes thanks to a special prosecutor assigned to the case. He says racial bias is why County Prosecutor Bob McCullough went for the death penalty in Johnson's case. He notes that a white defendant who killed a cop was treated differently. And he's using the state's new wrongful conviction statute, which allows prosecutors to intervene, to try to halt the execution. It's not quite that simple, though. This is a very complicated thing that got us to this point. Erin, I'm hoping you can just help us explain how we ended up with the Missouri Supreme Court saying, okay, this is the very last minute, but we're going to have a hearing on Monday.
Absolutely. So the Supreme Court is considering whether or not to stay the execution to provide more time for the hearing involving the special prosecuting attorney. So the special prosecuting attorney was appointed only recently and only had about a month to evaluate the entirety of the court file in this case, which included 12 boxes, 31,000 pages of documents to review. And they filed their motion asking for the court in St. Louis County to set aside the verdict and judgment in this case. However, procedurally, the court needed to hold a hearing in which all parties had an opportunity to present evidence, including the Attorney General's office.
And when you say the court needed to hold a hearing, under the statute, it says this hearing shall happen.
Indeed.
Okay.
The word shall being the critical one. Shall, it means you have to do it. Right?
Okay. So that didn't happen here. Is that what the Missouri Supreme Court is looking at? Like, do we now have to do this and pause this execution?
What the Supreme Court is going to be looking at is whether or not to grant more time. And if more time is granted, then the special prosecuting attorney will have an opportunity to writ the decision already made by the judge in St. Louis County who denied their motion based in part off of a lack of time in order to hear this case.
So, Mark, do you think there's any chance that the Supreme Court could say, yeah, we need to put a stop to this execution? This can't happen on Tuesday.
Yeah, I would hope so. I mean, it seems like the law requires this hearing, and the judge has said they need time to brief it, so we should do that. Now, your listeners might be saying, well, why is this all happening at the last minute?
You are asking the question
Right.
I've been wondering.
And I think here's the things you need to remember. He was convicted, I think, in 2007, so a long time ago. But this law, the law that allowed a prosecuting attorney to kind of question a case where they think there's innocence, wasn't passed till became effective, I think, August 28th of last year.
This is a very new law. Very
new law. And Johnson's lawyers filed a request for a special prosecutor on October 12th. So right after within 6 weeks, they read the law, they do a filing. I think that's timely. And then on December 1st, they amended it. They did some other stuff. And the prosecutor, so Wesley Bell's office could be the one to investigate, but they realized they have a conflict because I think one of Johnson's former public defenders is now working in the prosecutor's office. So they have to appoint a special prosecutor. And that's harder than it sounds like because you have to get somebody who doesn't have a conflict. Apparently, if you do this, you cannot take, I think it said, any criminal cases the whole time you're doing this. So and I think some people turned them down. So they found this guy out of Kansas City who did the work. As Erin said, he did it in 6 weeks' time. And, I mean, he wrote a 50-page document that I thought was well done. And, I mean, I don't think he was sitting around. And he had in his filing, he talks about trying to interview people in the prosecutor's office. And McCullough just refused to talk to him, apparently.
This is the former prosecutor who was in charge of this prosecution of Kevin Johnson.
And then the assistants who were more intimately involved with the case said, hey, you have to talk to Bob McCullough, and I'm not going to tell you what we did and what we didn't do. So there was I don't think this was a case where it was people were dragging their feet or anything. And as Erin said, I mean, you've got he talked about boxes and boxes. There was this study done by this professor out of the University of North Carolina that looked at McCullough's office generally and had some findings that suggested race was playing an issue. And so I think, you've got this kind of finding. And what he said was that he said this looks inappropriate. It looks like race was used, and so you would hope before you take someone's life, the state takes someone's life, that you would do this the right way. And one
you would
last
consider
thing,
these claims.
Yeah, and one last thing because and I'm not a death penalty person, but I mean the special prosecutor noted this was a horrific crime. Nobody is suggesting that this wasn't. I don't think anyone's suggesting that the crime didn't happen or that it wasn't horrific. They're just suggesting the way the jury in particular and the way this prosecutor office picked which cases to take to the death penalty and which ones not is done adversely impacts black defendants.
Erin?
I think it's important to note also that the approach the St. Louis County's prosecuting attorney's office has taken in reviewing these types of cases, they've created an entire unit called the Conviction and Incident Review Unit, one of a kind within the state of Missouri. So this isn't an incident where the St. Louis County prosecuting attorney's office were dragging their feet. In fact, they informed the Supreme Court of Missouri that they were seeking a special prosecuting attorney at the time in which this execution date was set. Now, that doesn't seem to have been taken into consideration, or certainly there isn't evidence that was taken into consideration at the time of the execution date being set by the Supreme Court.
Eric, what do you make of that? It seems like the Supreme Court could have avoided this whole sort of crazy rush at the end if they had just paid attention when they said, hey, slow down setting this date. We're going to have a special prosecutor coming in and looking at this. Just pause.
Absolutely. What's the rush?
Yeah.
Right.
So when the Supreme Court looks at this on Monday, are they going to be looking at the merits, or are they just looking at, does the law say we have to, or somebody has to hold this hearing? I guess it would be the circuit court has to hold this hearing.
Yeah,
does anyone
Judge
have a sense of,
Yeah.
Does anyone have a sense of what question that they're going to be trying to answer on Monday?
I think, his findings, E.E. Keenan, I believe is
the
his
special
name.
prosecutor.
Right.
Yeah.
And his finding was the evidence clearly and convincingly shows improper racial factors played a substantial role throughout the process of both the prosecuting selecting defendants, seeking the death penalty, and selection of jurors. And so I think the judge then needs to consider this and see if we have to redo the death penalty phase, or he's asking for the decision to be vacated and referred back to a trial court.
Okay.
However, I think the issue in front of the Supreme Court is first whether to grant that time. And to make that decision to grant time for a hearing, they will have to explore some of the merits of the claims that were before Judge Ott. However, I don't believe the Supreme Court is actually going to rule regarding those merits. So the merits as to whether or not there was racial bias influencing this decision in this trial is not before the Supreme Court. However, they will weigh those factors when making a determination on Monday.
Deciding whether Judge Ott should spend a lot of time looking into those questions, that's what they have to weigh the merits of, is whether it's worth putting a ton of time and focus into this on the circuit court level.
Absolutely.
Okay.
And whether the law requires that. And I mean, it seems to me the law requires that.
Well, we'll see if the Missouri Supreme Court agrees with Mark. Now, you mentioned there, as we were talking, this issue of jurors, particularly black jurors, being struck. Prosecutors trying to get black jurors off of juries. This is something that I've grown interested in as a journalist, because as I've been looking at these death penalty cases, it seems to be such a common factor in these cases. The prosecutors are saying, we're going to find ways to get black jurors off these juries because they're not necessarily going to be sympathetic to what we're doing as prosecutors. Now, it's illegal to strike jurors for their race. This goes back to a case called Batson. Eric, people still seem to be able to do it using something called peremptory challenges. Is this basically a workaround?
Yes, it is. And for that reason, I believe that peremptory challenges should be eliminated, and you should have to have cause for striking any juror, because it is too easy to come up with subjective factors. This person didn't laugh at my jokes. This person looked at his shoes when I was talking to him. Just all kinds of ridiculous reasons.
And when you say that's a reason a prosecutor could offer, this person looked at my shoes when I was talking to them, and they could get away with striking that black juror.
Well, yes. And they have to have somebody raise the challenge before the prosecutor gives the reasons, or the defense attorney, too. So if you submit your preemptory challenges and nobody questions them, then they'll stand. But when somebody questions, then the onus is on the person offering the challenge to explain why.
So just so your listeners understand, you have 4 cause challenges. So if there's a jury pool and juror number 2 knows the police officer who was involved or is related to the defendant, well,
you can't have that person on a jury.
You can't have that. Judge says everyone agrees but you get your preemptory challenge, and you get a limited number, and it's just like, I don't have to tell you why.
I'm just getting rid of these jurors.
I'm picking these. And so if I pick all 5 of the African-American jurors, then you can't do that. And then you say, well, why? Why did you pick this particular juror? And so apparently there's a case, one of the cases or one of the articles talks about it. Prosecutor has said, well, because this person was a mailman.
It's a postal worker.
Postal worker, right. And I've got a bad, history with postal workers. So, I mean, I don't know what that's about, but...
well, what it might be about, I mean, what I see in my reporting is a whole bunch of St. Louis County postal workers are black.
African-American, right.
I mean, that's something where you feel like the judge should step in and say, hey, whoa there, you have a bad feeling about postal workers? Erin, is that something judges are likely to take on and call the bluff?
Absolutely. So the standard for providing a reason needs to show facial validity.
What does that even mean?
It's a neutral reason, a reason which would give somebody an ability to judge and believe that you had a reason that was neutral, not based off of race or a protected class, in order to strike this person. Now, Eric stated, some silly reasons that have been provided in the past, but I will say that our courts have been very responsive to some of these reasons that seem pretextual in nature. And we have had good cases in the last 10 years from higher courts that say, no, we believe based off of all of the circumstances that was not a facially valid reason for striking that juror. The other thing to consider, though, is especially when we talk about if we can eliminate all postmen from jurors based off of the fact that they work for the government, is the fair cross-section of jurors being selected as part of this master list. So each county creates a master list, and that is dictated based off of law we have in Missouri. But the list is created based off of government records like driver's license records, voter registrations, and personal property tax lists. Do those lists themselves inherently create a biased mixed pool based off of who is most likely to have a personal property tax record or a driver's license? And there's been studies that show that this does have an impact, especially on socioeconomic factors. So we're asking to have a fair cross-section of the jury, which is selected generally from something that might exclude people from our community. And then from that process, have a race-neutral or gender-neutral decision then from the actual jury pool. It's complicated, but thankfully we're given a lot of discretion to our judges.
It's complicated. In some ways, I can't help but wonder if it's broken. I mean, Eric, you mentioned you think a good reform here would be just getting rid of peremptory strikes entirely. That means you could only strike somebody for cause?
Yes, and that is no reflection on our judges.
Sure.
Because I think our judges do a great job of enforcing the law and making people give race-neutral explanations for their strikes. But I just think that, as alluded to before, the system is inherently flawed.
Arizona has moved away from, they're saying you don't get peremptory strikes. You have to have a cause. I don't think of Arizona as necessarily a progressive bastion. Say this as a former resident. Are you worried there could be a bad side effect of going that route?
No, I'm fine
Nothing to
with
lose.
it.
Yeah.
And I think it was an article you did, Sarah, about preemptory challenges. I mean, imagine you're the judge. You're put in a very difficult position.
Sure.
Because if I say I want to use my preemptory challenge on this African American juror, and then the defendant says, well, what's your basis? And I say, well, I got this postal issue, and then you, judge, have to come in and say to me, Mark Smith, I don't believe you, Mark Smith.
Yeah.
I think it's racial. And then I'm going to be like, Sarah, are you calling me a racist? I mean, and it puts you in a very difficult position, I think. And we all know each other. So yeah, I kind of agree with Eric. I'm fine with getting rid of preemptory.
And Erin, I see a big disagreement here. Whoa, your reaction to that, you want to keep these peremptory strikes.
Absolutely. So peremptory strikes exist in all types of cases involving criminal and civil trials. And it provides an opportunity for a party to strike a juror who may have survived a challenge for cause. And when we're challenging somebody for cause, we're really looking specifically at whether or not they can be partial or impartial in a sitting for that particular suit. The problem is that it is easy to survive a challenge for cause. And so you may have a juror who is, based off of their own answers and questions, going to already come into a trial disfavorably towards your party. And that does not guarantee due process. That is not something that is a fair cross-section. And so I think if we go into the extreme route like Arizona took, certainly there needs to be a substantial need for more leeway and broader use of jury selection conducted by the attorneys. And that's not something we necessarily practice right now in Missouri.
So Erin, in part, does employment discrimination suits from the plaintiff side. Back when I was practicing, I did a defense side. So as a juror, I loved like a juror who was a manager, because and I suspect Erin is not a big fan of those types of folks as jurors. And even though Erin's not saying they can't be biased, she's not saying they're biased. She's just, in her mind, knows this person is going to think more like Mark's client, and I'm not as keen on that person. And So I get where you're coming from.
Yeah, but I'm coming from. I remember watching the O.J. Simpson case where they spent like months trying to hand choose the perfect jury. Is that really what our criminal justice system should come down to? Is who has the more expensive experts in jury composition?
Well, but you don't get to do that. I mean, in most cases, it's not like in the movies. The judge says, "I'm going to ask the questions. You tell me, but we're going to move this along because I want to get things."
Judge Ito didn't do that, Mark.
Yeah, Judge Ito, right. And that's what most people are basing it on.
We're talking to our Legal Roundtable today. We do need to take a quick break here. We'll be back in just a minute. Stay tuned. This is St. Louis on the Air on St. Louis Public Radio. Welcome back. We've been talking about the Kevin Johnson case. He's the Kirkwood man who is ordered to be executed on Tuesday if the Missouri Supreme Court does not intervene. You may have questions or comments about this case. I'm going to open the phone lines. 382-TALK. You can send us a tweet at STL on air. If it's a legal question, we're going to try to get to it. If it's a moral question, we might not have the right panel for that. No insult to my fine panelists, but
None taken.
Theologians have a lot of thought on this, and they are not with us today. Now, there's another layer to this Kevin Johnson case, and this deals with his daughter, Corey Ramey. They are very close. She was very young when Kevin was sent away to prison after killing this Kirkwood police officer. She says she wants to be there to bear witness to her father's execution. She's not allowed to do that. It turns out this comes down to a Missouri state law. You have to be 21 years old to witness an execution. Corey Ramey is just 19 years old. The ACLU has now filed a lawsuit on her behalf. Eric, what do you make of this lawsuit?
What I make is that the law needs to be changed. That law is Section 546.740 of the revised Missouri statute. So the prison administration is just enforcing the existing law. But that existing law was written in 1939.
Oh, wow.
And the last time it was revised was 1995. So if you're old enough to serve your country in the military, you're old enough to watch an execution.
And what about, I think one of the ironies of this case is that Kevin Johnson himself was 19 years old when he committed this act that now has him sentenced to death. And so the state is saying, hey, you did this at 19, you can be executed for it. And yet your daughter, who's now 19, can't be there in the room to see it. Am I right in seeing a kind of a weird parallel here?
Yes, it does. The law does not make any sense at all.
So, Mark, in this lawsuit, the ACLU cites the 14th Amendment and the First Amendment, saying that this is what should give Corey Ramey the right to be there. Are these applications of these amendments you've ever seen before?
I haven't thought about that, and I think this is a pretty unusual case. So I guess I think her argument was it was association.
The First Amendment, apparently, I didn't even know this about the First Amendment, my favorite amendment. We have a freedom of association in that?
So she should be there with her father. I don't know. This is, I think, a pretty strange area of the law. It doesn't come up a lot. But I think it's probably more powerful as as a news item to make people think about this. I'm not sure the state of Missouri is going to change their opinion, and I would imagine, who knows if this, because of the stuff we were talking about before the break, if this would be maybe the death penalty phase would be retried or reconsidered by, with Wesley Bell making the decisions, maybe they would decide we're not going to go for the death penalty. We're going to just do life in prison.
Yeah.
I don't know.
I mean, something that has changed so much since this all happened back in 2003 and then the trial in 2005 is we now understand so much more about juvenile brains, that a 19-year-old isn't fully developed in the way that somebody is when they're 26 years old.
Well, and part of this case and part of the argument is particularly with a white defendant, they were McCullough's office asked for mitigating factors, and
this
Johnson
was a white defendant who killed a cop. This guy Trenton Forster.
Exactly.
Yeah,
right. And Johnson wasn't able to do that, and there was issues of mental health and the fact he had a horrible childhood where he was in foster care, and he was I think his parents were killed early when he was really young. So, not saying that excuses the behavior, but perhaps advocates for a different type of punishment.
Well, certainly I think it's worth noting that in the very first trial involving Kevin Johnson, there was a stalemate within the jurors regarding the consideration of murder in the second degree. Mm-hmm. And so in Kevin Johnson's case, there was, I believe, a confession involved in which there isn't necessarily a question of fact regarding whether or not he was involved in the death of this police officer. But there are a lot of legal factors involving the intentionality of it. Right. There are mitigating factors that jurors are supposed to consider, and it sounds like they considered those factors to even the extent of being held up on the idea of murder in the second degree. Certainly, if a jury was impaneled and considered murder in the second degree and found for that, then death would no longer be an option. So even if Wesley Bell's office considered pursuing the death penalty, the question before the jury may be the same with a completely different outcome.
It is interesting. And Wesley Bell is on the record saying that he does not believe in the death penalty. He's not going to do that in any case, not just in this case. So, well, this case is boy, there's just so many legal issues here. We're going to know a lot more next Monday. Maybe not by Monday. Maybe they won't make their decision by Tuesday. But we will know a lot more
I think his execution is set for 6 o'clock on Tuesday.
On Tuesday.
I mean,
yeah.
Just to imagine that you're going to have, they're telling you on this Thanksgiving weekend, Monday we're going to let you know one way or the other.
This could happen, this could not happen. It's what's hanging over his head right now. It's unimaginable. Let's switch gears here, talk about a case that I know several people on this panel find a little more humorous. We could maybe use a little break from the more serious stuff. Back in 2018, a pastor and his associate were giving bologna sandwiches to homeless people in downtown St. Louis. A police officer cited them. They were allegedly violating a city ordinance requiring a permit for the distribution of, quote, potentially dangerous food, bologna sandwiches here. The two men filed a lawsuit challenging the ordinance. The district court issued summary judgment for the city, and now the Eighth Circuit Court of Appeals has agreed. Eric, are you surprised? The Eighth Circuit is coming down in favor of the city, saying, yeah, you can regulate people trying to feed the needy?
Yes, I am, but I think that what's in play here is the schism, the disagreements between New Life Evangelistic Center and the downtown business community, especially along Washington Avenue. So I think that the police officers were looking for any excuse to harass the ministers at New Life Evangelistic Center, and they found one with this ordinance.
And now the court has said you can do this. What do you make of this ruling, Erin?
Well, certainly the question before the court was more focused on the First Amendment. So governments can regulate what's considered inherently expressive conduct, and this is what was being argued by the plaintiffs or the defense with handing out sandwiches to the needy and to the poor. So there can be regulation of that even without violating the First Amendment if there is a substantial government interest. So in this case, St. Louis City said they are preventing the spread of disease and provided some evidence that may or may not be compelling to everyone regarding whether or not they are preventing the spread of disease. However, looking at the existing ordinance, I think that calls into question some of these concerns raised by Eric. For example, the ordinance allows serving foods with limited preparation like hamburgers and hot dogs, but doesn't allow sandwiches that contain meat and poultry or fish. So is a hot dog a sandwich, or what's the difference difference between a sandwich with meat and a hot dog
One
between
would
a
hope
bun.
a hot dog has meat in it. I mean, that's what I've always kind of assumed, but you're right.
You can't be too sure.
Yeah, right.
And this is a First Amendment thing because they're saying this is the practice of their religion.
Exactly. There's an idea that they are pursuing and in pursuit of that religion by providing to the homeless. And I think we also need to see if the city's position is in fact that there's a legitimate interest in preventing the spread of disease. What other actions are they taking involving the homeless?
Are they taking any?
Or does this go more towards political motivation and strife, as pointed out by Eric? So I know that this year we've had a lot of issues involving homeless encampments being boarded up, homeless encampments being essentially shut down. And so what, in fact, is the city of St. Louis doing to protect the homeless, as they say they are doing by pursuing enforcement of the ordinance?
Yeah, I mean, if you talk to people in the provider community, they are livid at how the city is handling everything related to homeless people living within the city. And yet the Eighth Circuit didn't really even seem to look at that. Like, is this hypocrisy? Does the city have a pure motive? That didn't come up. Now, Dave Rowland, who's been a panelist on this show, he really is somebody who cares deeply about religious freedom. He is the attorney on this case. He says the men are going to appeal the case. He says they're either going to the Supreme Court, which would be their next step in the federal system, or they're going to go through the state court system. Mark, if you had to give Dave any advice, what would you do if you were him?
Oh, I think the Supreme Court, they only take about 100 cases a year. So
the odds are not good
likely.
for that. Yeah.
No, here's what I was going to say. I mean, this is just an unfortunate situation. I feel bad for the city. I live in the city, and homelessness is an issue that hurts the city, and there are some resources, maybe not enough, but sometimes the folks don't want to take advantage of those because for whatever reason, and I'm very sympathetic, but And New Life is a little bit different, but over by the River de Pere, we had all these tents set up, and people, and there's on a bike path they had set up, and that's not a good thing.
But is the answer to criminalize feeding them?
No, it's not criminalizing homelessness. Right? No, you're exactly right. But what do you do when you do have facilities and somebody says, a homeless person says, I don't want to take advantage of those because I'd still like to do some drinking on the side, and you're not going to let me do that. And I understand that, but does that mean they get the right to set up a tent on the bike path down by 55? I'm not sure.
Yeah. Erin?
Well, and to be clear, there are several compelling reasons involving a decision going into whether or not to take advantage of available homeless shelters. Yes, substance abuse is certainly one thing that may factor into that decision, but also the fact that there is crime, that there is incidences involving violence, that there are individuals who have extremely mentally health issues that would make it difficult for them to comply with rules within these shelters. So this is more complicated than we don't want to feed homeless, more complicated than we shouldn't shelter them, but certainly I think compelling, and I hope that we see a positive response from St. Louis City.
And this is, I think your point about the mental health issue, that's a huge factor in this. And I don't know what the solution is.
Welcome back. Our Legal Roundtable is in session with 3 top attorneys. Erin, you had a big victory earlier this month. This was in St. Louis Circuit Court in the city. You sued the owner of the Mercedes-Benz dealership on Hampton Avenue. 2 former employees claimed they'd endured a hostile work environment. And I know you have to be somewhat careful about what you say about this case. Appeals have not been exhausted. But can you tell us the conduct at the heart of these claims?
Absolutely. So Marianne Sadeh and Ben Westhoff are both partners in the law firm, and they've been working with 2 plaintiffs plaintiffs for several years. So this is one of those cases that, unfortunately, as a result of COVID, went longer than intended. But in this case, we have two plaintiffs, two women. One of them is also a person of color. And so our claim was that there was a hostile work environment based off of race discrimination, gender discrimination, and retaliation as well. We also brought a claim involving constructive discharge, and the jury found in favor of both plaintiffs on all four claims.
So constructive discharge. When I think of discharge, I think of the gunk that comes out of my eyes when I have pink eye. I know everybody wanted to have that image in their head as they head into Thanksgiving. What is constructive discharge?
So in constructive discharge, we ask jurors to consider whether or not the circumstances involving the employment were so hostile or the harassment so bad that an employee had to leave or was forced to leave. So in this case, we had two plaintiffs who resigned as a result of that harassment. And so jurors are asked to consider whether that the working conditions were so intolerable that an employer could have reasonably foreseen that an employee would resign as a result of those actions.
That's interesting. Eric, I feel like we hear a lot about people getting terminated and then they'll file a lawsuit over getting terminated. People who are sort of compelled to quit, they can also end up with a pretty good legal claim.
Yes. Yes, they can. And I believe that when an employee files a charge, the employer should treat the employee better and not worse, because the employee, if it can prove that it was retaliation, that's a whole different cause of action.
It feels like retaliation is where so many employers mess up.
Yeah.
Like somebody files something and then it's like, I am going to just come down hard on this employee. That seems to always backfire.
Yeah, you don't want to do that. As Eric said, you're going to get in terrible shape. Here's what I found interesting about this case. You mentioned it was in state circuit court. Mm-hmm. Most employment discrimination cases occur in federal court. And so there was some very good lawyering on the plaintiff's side that they managed to, because as a former defense lawyer in these cases, I didn't want to be in St. Louis City State Court. I wanted to be in federal court for a variety of reasons. Jury pool and just judges move things along and the case law is better. And so they did not give the defendants an opportunity to remove it to federal court, which is to take it there. And the two ways would be if there's a federal claim, so they only alleged state claims, and then they were lucky that they didn't have complete diversity of people different places. So if this had been an employer that was only in Illinois, they could have got it removed. But anyway, it's a very smart lawyering job, and this is a big win.
$1.8 million.
I mean, in employment discrimination cases, you don't get this kind of awards typically. This is a big deal.
And I'd also add, regarding retaliation, to Eric's point, the Equal Opportunity Commission, EOC, has a guidance provided and posted publicly for employers on what to do if there is a complaint. And it addresses specifically how to avoid the appearance of retaliation. And I think that's where a lot of employers may get hung up on, is not providing those safeguards in place in order to avoid any appearance of retaliation. So I'd highly recommend for employers to make sure they're familiar with those guidelines, especially after this verdict.
Upper management needs to come in, because if you sue us before you've left employment, and I'm your immediate supervisor, the way I read it is you're saying I'm sexist or I'm a racist or whatever, and I can't have that. So management's got to come in and say, just simmer down. This is not about you. We want you to follow these rules, and you lay them out, and you got to treat her the same way, and we got to move this along.
Something else I found interesting, the Post-Dispatch did a pretty good write-up about this verdict, and they reported that the defense called witnesses that ended up confirming the women's accounts. And so the defense thought these were going to be witnesses that would help them say, oh, no, they were not harassed. And they ended up, the testimony that was drawn out from them ended up proving just the opposite. Eric, you've been involved in a number of cases. How do you safeguard having a witness you think is favorable end up turning on you and put the nail in the coffin?
You don't. It's just a risk that's inherent with jury trials, or trials in general.
That a witness can go south.
Yes. And you're rolling the dice anytime that you don't settle the case.
This is why Eric always says settle. This is true.
You should always settle. I agree with that. But, I mean, you should you should know all your witnesses' story. I mean, you don't want to have any witness coming up and not knowing what they're going to say. So you depose them before taking their testimony under oath. You ask them all the difficult questions. You got to know what's happening. You can't go in there and just say, well, let's see what they say.
Yeah. Erin, what's the key to getting them to go south on the other side?
Marianne Sade.
I should say Marianne has been a panelist on this show, and boy, is she just a firecracker and such a good attorney.
Absolutely. So I think to some extent you can prepare any witness and prepare them for cross-examination, but ultimately you are putting a lay person 9 times out of 10 up on a witness stand in front of a public courtroom, and they are under an immense amount of stress. And so I always talk about the reptile brain. When you're under that amount of stress, your default systems kick in, and so it becomes harder to regulate against those types of answers or those types of questions that are being thrown at you. And so when you have an effective lawyer who can effectively cross-examine, that's when good things happen.
Good things for your side.
Yeah, or bad things, right.
That's why Eric says you always want to settle the case. Erin, leave us with a takeaway. What can we learn overall from this case and from your $1.8 million victory?
Certainly, I think it's encouraging to women and to people of color that in St. Louis City, they heard a lot of evidence from both sides and they decided to believe women. So many times in cases involving any type of discrimination, it boils down to he said, she said. Very rarely do you find a smoking gun, if you will. And I think it is very encouraging to all people out there, all employees out there, that we have jurors who are willing to believe you and find in your favor, and with punitive damages, hold those companies accountable so that hopefully they make better decisions in the future.
So another labor and employment case was in the news this month. This one involves Rockwell Beer Company. It has 2 popular breweries in the city. They were sued by the federal government. The Labor Department alleged that Rockwell improperly kept tips from employees by letting its former director of hospitality take part in the tip pooling arrangement. Mark, how big of a no-no is that?
So as a former bartender, that's how I put myself through law school. I'm very sensitive to this. The way it works, you have to be paid the minimum wage. But if you're in a job where you get tipped, in Missouri, your employer can pay you, I think it's $5.58 an hour. And then the tips, as long as your tips get you up to, I think it's $11.15 now in Missouri. But the tips oftentimes are pooled, but they can only be pooled with other tipped people. So if you put in cooks and dishwashers, they don't typically get tipped, and so that would be a violation. And here they put in like kind of a management type position. Another kind of interesting twist on this tip thing is, if you're doing as a bartender, if I'm also my boss tells me, and I want you to come in on Saturdays and clean the parking lot. Well, that's not tipped work, and so I can only have a percentage of that work. But if I do it like before work, well, then, it's not tip work. But if I cut lemons while I'm making drinks, it is my tip work. So it's a really complicated area.
Yeah.
So bottom line is, if you're an employer, you got to make sure your attorney has told you what to do and that you're following the rules, because you can get hit with, if you're not paying minimum wage, then you can get sued for that, or the federal government will come in.
Boy, I mean, to see the federal government come in on this, there's so many injustices I see all around me that the federal government is happy to ignore. But it sounds like they take this issue of wage theft and people helping themselves to a tip jar, they take this seriously.
They certainly do. And to get to the point where a lawsuit was filed, the behavior was mighty egregious, because the Department of Labor is going to try to settle these types of charges ahead of time. As a result of not settling this, Rockwell Beer Company is liable to double the damages.
Wow.
So if they owed, hypothetically, $25,000 in back wages, improper calculations of overtime, they're now on the line for $50,000.
So you think the feds would have tried to settle this before they got to the point of filing this lawsuit?
They always try to settle it.
Why would Rockwell not try to make this go away? This is going to get...
Hubris.
Hubris? Erin, have you seen this? I mean, you do labor and employment, that an employer might be like, yeah, whatever, we're not going to deal with this. The next thing you know, the feds have smacked you with a lawsuit.
Absolutely. And I think it is very encouraging to see the Fair Labor Standards Act in action. It's encouraging to see enforcement of that. I think that more employees need to be aware of their rights, as Mark pointed out, that they are due a minimum amount of money, and that is a guarantee. And so holding and making a show of employers being held accountable to making sure that people can make a living wage is a great step forward.
So is it too late for them to settle now?
No. Until the jury comes back, it's never too late to settle.
Okay, so your advice, you want them to settle this thing.
Well, I don't care, but that would be the prudent thing.
The prudent thing,
we had another case recently with the guards, the correctional officers at the prisons. And so I've been going out to the prisons because I'm teaching my class there. And, I mean, there they got in trouble because the guards have to go through all these hoops before they, you just
they get
don't
on
show
the
up.
clock.
Yeah, and you got to come in and you got to get your radio and you got to go through the security and the prisons were trying not to pay them for that.
And wasn't that like $100 million
verdict? It went on
verdict?
forever. It was huge. And you got all these correctional officers at all these places.
And what's that term, dining and duffing or something like that, where it's the term for getting ready to go to work.
Oh, yeah.
So.
Yeah, you have to get paid for your donning and duffing.
Yeah.
I like this precedent. I think we should bring this over also to journalists. I need to get
and
paid
these are
for
people who
duffing.
are not making a lot of money.
Yeah.
So it's not like, I mean, many, high-paid jobs, you're exempt. You don't even have to do this. So these are people who should be getting the money that they're owed.
So in our final few minutes here, I do want to mention something of great interest to lawyers across the state. Missouri has a new attorney general. Eric Schmidt is soon to join the U.S. Senate. He's apparently deposing Anthony Fauci today, but as soon as he gets done with that, he's going to join the Senate. Governor Mike Parson announced his replacement this morning. Andrew Bailey was Parson's general counsel last year. He'd served in a deputy role for 2 years. Mark, is this the equivalent of choosing Harriet Miers for the Supreme Court? Going back to the Bush years here.
Yeah, I remember her. Yeah. I don't know that it's a Supreme Court. I think that's fine. I don't know this guy. It sounds like Erin kind of knows him, but I mean, it's the governor's prerogative. And
he
he
gets to pick.
Yeah, I don't see anything wrong with this guy.
Erin, is there anything wrong with this guy?
I was excited to learn that Andrew Bailey was being appointed. He served as a prosecuting attorney. He's worked also for the Missouri Department of Corrections. He was essential with working with me particular in getting a grant throughout the state for crimes against children that was given by the governor to several prosecuting attorneys' offices and agencies in order to support the pursuit of those crimes against children. In my dealings with him, he's been very level-headed and even-handed and goal-driven. And I think that that's something we need to see with the Attorney General's office, and I'm excited to see what he does in the upcoming years.
So the Attorney General's office in the state of Missouri has been involved in a lot of national, very prominent right-wing type battles in the last couple of years. Eric, do you think we could see just a different focus coming out of this office now that it's somebody who doesn't, at this point, hasn't suggested any ambitions to be a senator?
I certainly hope and pray so.
Yeah, you want a lawyer who's kind of boring, who just follows the law, does and doesn't get a lot of, like, let's sue these people. That's an interesting idea.
Yeah. We should mention, however, that Andrew Bailey does say that he is going to run for this position in 2 years. He was asked that. And so maybe he is an aspiring politician as well. But, maybe somebody who will focus on the business of the state.
And there were other people who were hoping to get this appointment.
A whole bunch of people. Yeah. It'll be interesting to see if any of them run. Mark Smith, I want to thank you so much for joining us today.
Oh, it's great. It's always fun to do this.
And Mark is a former associate vice chancellor and dean at Washington University. Erin Banks, attorney and mediator at Banks Law. Thank you for joining us.
Thank you for having me.
And Erin Lueker, Sade Harper Westhoff, attorney there, making your Legal Roundtable debut. Erin, you were awesome. Thank you so much for joining us.
Thank you for having me.
I hope we can get you back again.
Always.
This episode was produced by Alex Hoyer.
Our audio engineer is Aaron Dorr. Our production intern is Avery Rogers. This podcast was mixed and edited by Aaron. Our executive producer is Alex Hoyer.
St. Louis on the Air is a production of St. Louis Public Radio. Understanding starts here.
Our podcast proudly supports St. Louis artists by using music from Life Creative Group. Do you find yourself regularly listening to episodes of St. Louis on the Air? Suggest us to a friend you think might enjoy our conversations, and leave us a review and rating on Apple Podcasts on the App Store. It's the simplest way to help people discover our show. Thank you.
St. Louis Public Radio is a member-supported service of the University of Missouri St. Louis.
Support comes from the Missouri Forest Products Association. Missouri produces wood pallets, railroad ties, white oak barrels, hardwood floors, and more. Details on the variety of products made in the state are at choosewood.com.